Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, we're in session number 5 of our new series entitled The QME Forensic Super Sleuth. And the philosophy of this program is all about how you as a qualified medical evaluator have the responsibility to determine for yourself what are the issues that drive the need for the evaluation, number one, and number two, what are the issues that you're being called upon to resolve as an expert QME evaluator. And it would be great if the parties would just provide us with this information up front so that we can do what we're supposed to do and answer the questions that we're supposed to answer and resolve the issues that we're supposed to resolve. But for whatever myriad reasons, the parties, either by commission or omission, many times fail to inform us of the important information which, if we knew, we could satisfy the parties by providing the opinions and conclusions that they need to resolve the issues on their end of the bargain. But the parties, for whatever reason, don't always provide these details to us, and so it's incumbent upon us that we figure it out on our own. And in sessions number 1 and session number 2, we talked about the paperwork and the laws behind the need for the QME evaluation in the first place. We talked about QME forms 105 and 106, which are the paperworks that the parties submit to the Division of Workers' Compensation to order an evaluation with you, the qualified medical evaluator. And on those forms, the parties indicate the issues that are in dispute. Unfortunately, we as qualified medical evaluators don't have access to those documents, and so by the time the evaluation comes to us, we are unaware as to the disputed issues for which we're being called upon to resolve. And then we talked about labor codes 4060, 4061, and 4062, which are the labor codes that drive the need for the evaluation with you. And different disputes, different disputed issues are resolved under different labor codes. And there's only 3 labor codes that govern the entire QME process, so if you can understand each of these labor codes, you'll understand what is your role during the evaluation between you and your examinee. So those are facts and details that the parties don't provide us, that it's incumbent upon us to discover for ourselves. So that was sessions number 1 and session number 2. And then in sessions number 3 and sessions number 4, we embarked upon a new series of topics that, again, comprise a bulk of the evaluations that we're getting, for which we are not informed in advance as to the situation involving the examinee, and that has to do with the post-employment claim of an industrial injury. And these are claims for industrial injury when the claim is filed on a date after the employee has separated his or her relationship with the employer. So the claim is filed post-employment. And post-employment claims are going to form a bulk of many of the evaluations that you're currently getting and that you're going to be getting in the foreseeable future as the number of post-employment claims explodes throughout the state of California, especially in Southern California. So we talked about some of the statistics regarding post-employment claims, and I have a few more statistics to share with you today. We talked about what the 2017 RAND study had to say about post-employment claims in general, and specifically what they had to say about post-employment cumulative trauma types of claims. We talked about the differences between specific and cumulative trauma post-employment claims. And then we spent the bulk of our last session talking about Labor Code 3600, which as a law and as a rule generally prevents, bars, bans, and prohibits the filing of claims post-employment except in certain circumstances. So Labor Code 3600 was written and passed by legislators and lawmakers who found it necessary to prohibit the filing of claims for industrial injury post-employment. Why is that? Why would lawmakers, in their infinite wisdom, prohibit the filing of claims post-employment? Well, we could speculate as to the reasons on that all day, but suffice to say that lawmakers found through experience and research that the filing of post-employment claims was many times not a bona fide circumstance of an injury that occurred prior to the separation of employee and employer, but rather they found that these types of claims were many times filed in an effort to retaliate against the employer. So they passed Labor Code 3600 to prevent these types of claims from being filed. But as they sat around talking about these types of claims, I can imagine lawmakers sitting around a round table, and one or more lawmakers raised their hand and said, well, you know, ladies and gentlemen, there probably are a few circumstances where claims that are filed post-employment are legitimate claims. Wouldn't you agree, all of you, that perhaps there are some circumstances? And they all agreed, and they set forth some circumstances wherein post-employment filing of claims, both specific and cumulative trauma injury claims, would be permitted. And these are the so-called exceptions, the exceptions to the post-employment defense. Now, in general, the law prohibits the filing of claims post-employment, except for a few certain situations and scenarios, and we began talking about those in our last sessions. And we went over Section 10A of Labor Code 3600 and Section 10B, and both of those had to do with situations where it appears that in all actuality, the employee may have actually suffered an industrial injury prior to his or her separation with the employer. So these exceptions represented those circumstances wherein the claim was legitimate. The injury was legitimate because the employer had evidence of the injury prior to the separation of the employee from the employer, or the employee's medical records existing prior to the notice of separation or layoff contained evidence of the injury. So those were examples wherein a legitimate injury had apparently occurred, and the lawmakers provided an exception to the post-termination defense by allowing these types of claims to move forward. In today's session, I want to talk to you about a couple of additional scenarios that are also the exceptions to Labor Code 3600 that will allow these types of claims to move forward. And as we go into today's discussion, you're going to see how the exceptions that we talk about today create the loophole whereby thousands and thousands and thousands of new claims for post-employment industrial injury can be filed, especially as relates to the cumulative trauma types of injuries. And you're going to find this to be a fascinating discussion, and I can promise and guarantee to you that you're going to see these scenarios, you're going to see them newly for the first time, or I should say that you're going to recognize these scenarios as operative in 8 out of your next 10 face-to-face evaluations. So it's critical that you as a qualified medical evaluator understand the laws and the strategies behind these types of claims. Okay? So before we get into the dates of injury for specific and cumulative trauma injury claims, let's just go over a couple of more statistics about cumulative trauma in general. Okay, so what I want to share with you now has to do with some important statistics that qualified medical evaluators need to be aware of in evaluating examinees who are reporting cumulative trauma injuries. So what we have here is we have a recent study from the Workers' Compensation Insurance Rating Bureau of California, and I believe this is a late 2017 study, which contains the very latest and most recent statistics regarding cumulative trauma injury claims. And if you're thinking to yourself that, well, 2017 doesn't sound very recent, in fact, this is being recorded in 2020, and the reason that is it takes time. It takes years for all of the statistics regarding cumulative trauma injury claims to come in, because many times these claims, these types of claims, are filed years and years and years after the separation of the employer from the employee. And that makes cumulative trauma injury claims unique. And we'll talk about exactly why it is that cumulative trauma injury claims can be filed at such extended durations after the employment situation has ended. So that's why these statistics are just coming in now from 2017. And I want to share with you a couple of things from this report that's important for us as qualified medical evaluators to know. The first has to do with the percent of total claims, total industrial injury claims that are cumulative trauma injury claims by region throughout the state of California. So let's go to that chart here. And this chart shows a map of California, and different regions within the state of California are identified by the percentage of total claims that are cumulative trauma injury claims. So the states here in blue have a very low percentage of cumulative trauma injury claims. For example, the chart tells us that only 3 to 4% of all claims are cumulative trauma injury claims. But then, as the colors change and become increasingly towards the red, we see that certain parts of the state down here in Southern California, where there's a high percentage of orange, dark orange, and even red, these are the areas of the state that have the highest percentage of cumulative trauma injury claims, with the epicenter of the cumulative trauma claim universe being in the Los Angeles, Long Beach area of Southern California. So if you're in Southern California, you're going to be getting a high percentage of these cumulative trauma injury claims. And what this chart doesn't tell us is that even though cumulative trauma injury claims can form perhaps only 9 to 10% of all claims filed, it's these types of claims that are particularly prone to requiring a qualified medical evaluation to resolve the disputed issues. So it's more than 9 to 10% of the cases that you're going to be seeing as a qualified medical evaluator. It's actually going to be much higher. In my experience, it's going to be 50 to even 80% of all cases that you're going to be assigned as a qualified medical evaluator will have some component of cumulative trauma associated with the disputed issue. So let's read what they tell us here in the table. They tell us that Northern California regions have relatively lower cumulative trauma claim rates, with the lowest rates in the Santa Cruz, Monterey, Salinas area. Southern California regions in general have higher CT claim rates, with the highest rates in the Los Angeles, Long Beach area, which are more than 3 times greater than other regions. And we could speculate at great length as to why these regions in the state would have such a high percentage of cumulative trauma injury claims. So that's one thing I wanted to share with you. And then I want to share with you 2 more things. Now, this is particularly important for qualified medical evaluators to know, and this has to do with the medical legal costs related to specific injury claims and medical legal costs related to cumulative trauma injury claims. So in green, we have cumulative trauma injury claims the average amount of money paid per medical legal report, and you can see across all years, the cost of medical legal reporting for cumulative trauma injury claims exceeds the cost for specific injury claims, which are identified here in orange. So that may not come as such a surprise to you, but what is a surprise are these lines right here, the blue line and the orange line, and what those depict is the percentage of claims that require medical legal reports, comparing cumulative trauma injury claims in blue here compared to the percentage of claims that require medical legal evaluations for non-cumulative trauma claims with the yellow line in here. And you can see, according to this graph, that across all years, the number of cumulative trauma injury cases that require a QME evaluation greatly exceeds the same scenario for specific injury claims. Specific injury claims require dispute resolution through qualified medical evaluators at a much lower percentage than do cumulative trauma injury claims. They tell us that cumulative trauma injury claims are more likely to involve medical legal reports, and the reports on average cost much more. So this explains why you, as the qualified medical evaluator, can expect to see a flood of cases that involve allegations of cumulative injury, and that's why you, as a qualified medical evaluator, need to identify this phenomenon when it's happening and when it's operative in your evaluation of your very next examinee. And then finally, what are we going to see in these types of cases when we actually do get claims for cumulative trauma injury? This chart here shows the top 7 medical diagnoses for cumulative trauma claims compared to non-cumulative trauma claims. And the WCRB tells us that 5 out of 7 of the top diagnoses for cumulative trauma claims involve injuries to the upper limbs, which represent 25% of medical transactions, whereas specific injury claims are much more likely to involve back injuries or back sprain types of injuries. So for cumulative trauma claims, the principal diagnoses that we're going to see involve the types of upper extremity injuries that can reasonably be the chronic type of repetitive strain lingering injuries that persist even for time periods extending beyond the employment period. So carpal tunnel syndrome, hand-wrist tenosynovitis, lateral epicondylitis, and these chronic type of injuries are what we're going to expect to see in these cumulative trauma injury claims. Okay, so let's now go back into Labor Code 3600 and talk about how it is that these types of claims can be accepted and can be admitted into the system by examining a couple more of the exceptions that lawmakers provided in order to allow these types of claims, to allow legitimate situations of these claims to become accepted injury claims. Okay, so now back to Labor Code 3600, which is in general the post-termination defense law that prohibits the filing of claims post-employment. But lawmakers, in their wisdom, thought about it, and they came up with a few scenarios wherein an actual injury could have actually occurred prior to the employee's separation from the employer, for which the employee would be allowed to receive workers' compensation benefits. And here, with regards to specific injuries, Section C of subsection 10 tells us that certain specific injury claims, even when they're filed in the post-employment period, can qualify as legitimate industrial injuries. So 10C tells us that the date of injury, as specified in Labor Code Section 5411, which we'll go over in a few minutes, is subsequent to the date of the notice of termination or layoff, but prior to the effective date of the termination or layoff. And that makes sense. That makes sense that even though the examinee gets a notice today, let's say today is November 15th, and the employee receives notification that on December 1st, they're going to be laid off. Okay, they received that notification on November 15th that on December 1st, that's the effective date of their termination or layoff. So they have a 2-week period of time that they're going to be continuing to work for the employer before being laid off. Well, is it possible? Is it possible that while working in this 2-week period here, that the employee could suffer an industrial injury? Of course it's possible. Of course it's possible. In fact, it's probable. Many employees continuing to work could indeed suffer an injury in this 2-week period of time. And as long as this injury is filed, the claim for injury is filed within 30 days of the date of the injury in here, then the claim can be allowed to move forward. So if the employee provides written notice of injury, even though it's filed in the post-employment period, see, the date of separation is December 1st, this claim is filed post-employment within 30 days, as long as that date of injury is in between the date of notification of termination or layoff and the effective date of notification or effective date of termination or layoff, the claim can move forward. But you'll notice that this is a very narrow window here. This is a 30-day narrow window, which allows legitimate claims during this time period to advance and to become accepted claims. So this is the type of information that you would determine from your examinee in the occupational history section of your interview with the examinee. And I submit to you that the occupational history in your face-to-face interview with the examinee is at least as important as the history of the injury section of your interview, as the relevant medical history section of your interview is as important as your activities of daily living assessment, because it's the occupational history interview that's going to give you these details about what are the operative labor codes and sections of labor codes that are driving the need for the face-to-face evaluation that you find yourself confronting with your examinee. So this is information that you would find in the occupational history section of your report. And this section, Labor Code 10C, has to do with specific injuries, and I submit to you because it's particularly tailored or that it's specific to specific injuries, and because of the narrow window involved for the injury and the reporting of the injury, this is a scenario that you're not going to see a whole lot of. You will occasionally see this type of scenario operative in your evaluation, but much more common is you're going to see the date of injury loophole, I'll call it, related to cumulative trauma injuries is going to be much more prevalent and much more prominent and much more frequent in the examinees that you're confronting in the face-to-face evaluation. So let's talk about what Labor Code 3600 has to say about the date of injury for cumulative trauma injuries, and there you're going to see where and why you're receiving so many post-employment cumulative trauma claims in the evaluations that you're getting. Okay, so let's talk about the exception that lawmakers have allowed under Labor Code 3600 to allow cumulative trauma injury claims, even when they're filed post-employment, to be allowed to move forward and to become accepted claims. So remember what we just talked about related to specific injury claims. When the date of injury for a specific injury is after the notice of termination or layoff, but prior to the effective date of termination or layoff, it's within that narrow window. And if the claim for injury is filed within 30 days from there, the claim can move forward for specific injury claims. And this is going to happen in some frequency, but I submit to you that it's a small frequency of cases. Much more common are the post-employment cumulative trauma injury claims because of the following loophole that's contained within the law. So to begin, we're going to need to go over 2 labor codes in order for you to fully understand why it is that you're getting so many post-employment cumulative trauma injury claims. Okay? So first, continuing with Labor Code 3600, Section D tells us that for cumulative trauma injury claims, the date of injury, which is an important line in the sand, it's an important date. The date of injury, as specified in Section 5412, we're going to go over that in just a minute, is subsequent. Subsequent means after, is after the date of the notice of termination or layoff. So for specific injury claims, the date of injury had to be after the notice of termination or layoff, but prior to the termination or layoff, within that narrow window. But this narrow window is going to be now removed and the ceiling lifted under the cumulative trauma injury claim, and it has to do with the date of injury. The date of injury. So the date of injury for these claims is defined in Section 5412, and 5412 tells us here that the date of injury in cases of occupational diseases or cumulative trauma injuries is that date upon which 2 things happen. 2 things happen. 2 things have to converge and collide and coincide and intersect to define the date of injury. 2 things. Number 1 is the date upon which the employee first suffered disability from the cumulative exposure, from the repetitive trauma, from the cumulative trauma, is the date upon which the employee first suffered disability therefrom. Disability meaning need for medical treatment or inability to carry out the full work duties. Generally, in this case, refers to the need for medical treatment since the employee has long separated from the employer. Okay, so this generally refers to the need for medical treatment. The date the employee first required medical treatment, and, so that's number 1. Number 2 is and. We have to have an intersection of 2 things. The second thing is that they knew, or in the existence of reasonable diligence should have known, that such disability was caused by the present or the prior employment. Prior employment is what is specifically being referred to here as post-employment filing of a cumulative trauma injury claim. So for cumulative trauma injury claims, the date of injury is the date of injury upon which the employee first suffered disability from the cumulative exposure and gained the knowledge, meaning he knew or should have known when he gained the knowledge that the disability, the need for medical treatment, the inability to work, the work restrictions, the total temporary disability was caused by the present employment in the case of cumulative trauma injury claims filed while still with the employer, or caused by the prior employment for those cases that are filed post-employment. And this is the great loophole. This is the great opening. This is the great seam that can be exploited that allows cumulative trauma injury claims to be filed in the thousands, even though those claims are filed post-employment, when these types of claims would be generally barred by the post-termination defense found in Labor Code 3600. Because it's this loophole, the knowledge, the subjective gaining of knowledge. This is subjective, correct? The first 3 exceptions to Labor Code 3600, Section A, 10A, 10B, and 10C, all involved objective criteria. Objective criteria. the employer had notice of the injury, the employee's medical records contained evidence of the injury, or the date of injury for specific injury claims was within a very narrow specific window. Those are all objective criteria, but here Section 10D opens up a subjective criteria, and that is the date upon which the employee gained the knowledge that the disability was caused by the prior employment. And this is where employees will tell you that they did not gain the knowledge that the disability was caused by the prior employment until days, weeks, months, years, decades following the separation from the former employer. So this explains why you're getting so many calls for post-employment cumulative trauma evaluations, because employees are being allowed to file claims post-employment when those claims for post-employment involve cumulative trauma, because it's the cumulative trauma portion that's basically unlimited by this exception in the loophole regarding the date of injury. You're not going to be getting as many post-employment claims for specific injury, because the specific injury exemption exists only for a very narrow, tightly confined set of dates related to the date of injury for specific injury claims. The cumulative trauma injury claims are unlimited. There is no cap on when these claims can be reported, and it's this particular loophole related to the date of injury that allows these types of claims to move forward. But as we saw in our last session, these types of claims are the types of claims that examinees typically have their claim for industrial injury denied by the claims administrator. So that raises the issue as to, okay, so I'm getting this type of claim. What therefore is my role? What is my role as the qualified medical evaluator in resolving these types of injury claims? So your role as a qualified medical evaluator in resolving these issues related to the post-employment filing for a cumulative trauma injury claim begins by recognizing when this scenario is operative in your evaluation. So let me just give you an example of how this might present to you in the evaluation. Remember that 10D tells us that the date of injury is subsequent to the date of notice of termination or layoff. So for example, on November 15th, the employee receives notification that on December 15th, within 30 days, they're no longer going to be working, they're going to be laid off 30 days later. Well, for a specific injury claim can fly if the injury occurs in this time period and the employee files the claim for injury within 30 days. So this is a 30-day time period. Okay, so imagine that the employee suffers an injury on November 16th. As long as that injury is filed by December 16th, it would fly. If the injury is suffered on December 1st, if it's filed on January 1st, which is post-employment, it's after the effective date of termination or layoff, but within 30 days of the date of injury, the claim can fly. So for specific injury claims, the window here is very narrow. But for cumulative trauma injury claims, if the employee gains knowledge that the disability was caused by prior employment subsequent to the date of notification of termination or layoff, the claim can be filed at any time, even years, and even decades after the employment relationship has ended, because the employee can contend that they only gained the knowledge at this time period. This knowledge generally comes in the form of an opinion from a medical evaluator, and this makes sense in the case of occupational injury claims. For example, with an occupational disease such as lung cancer, such as other types of cancer, such as respiratory conditions, such as other metabolic conditions. And a separated employee, an employee who has long retired, may not develop symptoms, may not develop disability or the need for medical treatment until years after they're no longer working for the employer. So imagine that an employee, a retired employee, starts to develop a cough 3 years into retirement, and the employee goes to his family practice doctor, and the doctor takes a history and finds out that the cough is likely related to a lifetime of work in an asbestos factory or in a dusty environment or in a coal mine. I don't know, I'm making this stuff up. But I'm sure you can imagine that there are cases where these occupational diseases don't manifest themselves until long after the employment relationship has terminated, and the employee gains the knowledge from a medical provider 2 years, 3 years, 5 years later. Well, lawmakers recognize the veracity and the sincerity of this particular type of situation, and they created an exception to Labor Code 3600 under Section 10D, which would allow these types of claims to move forward. Now, for the musculoskeletal cumulative trauma types of conditions, you may have to decide for yourself whether or not it's plausible that an employee a year later, 2 years later, sometime after separation from the employer, could continue to suffer disability and need for medical treatment for neuromusculoskeletal symptoms long after they're no longer working in the injurious environment. That's your job as a qualified medical evaluator to ascertain. But this exception here explains why we're getting so many post-employment cumulative trauma claims, because examinees, claimants, right, are claiming that they only gain the knowledge that their symptoms, that their disability is related to the prior employment. They're gaining that knowledge at some time long after the separation from the prior employer. So your role as a qualified medical evaluator in resolving these issues begins by recognizing the scenario when it's present. So once you identify that your examinee is presenting to you with a post-employment situation, in other words, once you identify that this is operative in your evaluation, then you can get down to work resolving the disputed issues. Now, unfortunately, the parties and the examinee themselves will not tell you this information. They specifically won't tell you this information if they're filing a claim for cumulative trauma post-employment. It's up to you to ascertain this information in the history-taking portion of your interview with your examinee. So step one to resolving the disputed issues in these cases and doing what you're supposed to do as a qualified medical evaluator begins with you taking responsibility yourself to ascertain the examinee's situation. And once you identify that a post-employment situation is operative in your examinee, then you can get down to doing the difficult medical decision-making of providing your opinion as to whether or not, within reasonable medical probability, the employee either did or did not suffer either a specific injury or a cumulative trauma injury, even though the claim was filed post-employment. And in our next session, we're going to talk exactly how the QME can go about providing a correct opinion on AOE-COE on these post-employment claims 100% of the time. And in order to do that, it's important that we as qualified medical evaluators understand the distinction between AOE and COE. So the disputed issue in these cases has to do with AOE and COE. As we talked about, these claims come to us generally on a denied basis. The dispute is over the compensability of the case, and the claim comes to us, the case comes to us under Labor Code 4060 for the compensability evaluation. So you see how all these labor codes are now tying together. Well, you as the qualified medical evaluator can very quickly and very easily resolve these disputed issues over compensability By understanding the distinction and your role in providing your opinion, AOE, COE, by focusing on the AOE details of the situation. And this requires that you be able to obtain an accurate history from the examinee. And in our next session, we're going to continue the philosophy of this program, and that has to do with what they don't tell us, what they don't tell us. And we've spent entirely now, up to this point in the program, in talking about how you as a QME forensic super sleuth can determine the issues that the parties don't tell us, Well, in the next section of our program, we're going to continue the philosophy by examining the details and the information that the examinee doesn't tell us. And we're going to talk about how to obtain an accurate and honest history from the examinee so that you can resolve the disputed issue on AOE, COE. And then finally, in the last section of this program, we're going to talk about depositions, and we're going to talk about what the lawyers, the attorneys, don't tell us, and what information they don't provide us in advance of depositions, which if we knew, we could perform much, much more credibly and much more accurately in depositions as well. So in our next session, I have a fabulous session for you that's going to be invaluable for you, not only in your post-employment cases, but also in every single case, because every single case pivots around accurate details obtained from the examinee in the history-taking interview in the face-to-face evaluation. So doctors, I hope this helps you in being able to understand what issues are operative behind the glut and the flood of cases that you're now getting and that you can expect in the very near future. And it begins with you obtaining an accurate occupational history to determine where in the examinee's employment history the claim for injury is being alleged. Okay? So I want to thank you for taking the time to join me on today's discussion. I look forward to being with you in our very next session of our new program entitled The QME Forensic Super Sleuth. For now, this is Dr. Perry Carpenter, wishing you best success in your career as a qualified medical evaluator.